Laws are generally used to provide justice to the people, and there are many instances where we have seen that laws are misused. As a result, many innocent people had to suffer. Hello everyone, welcome to the new series of Drishti IAS. I am Ritu and today we are going to discuss very important topic which is preventive detention of law, and this topic is related to Telangana state and this topic is important from GS2 perspective. So moving to the points of discussion part. So first of all, we are going to discuss the news and then brief about preventive detention, and then under what laws can the state order preventive detention, and then what are the powers of the state regarding this law, and then how do courts access this detention order, and then practice question for prelims and then mains. So moving to the news part. So you already know that laws are very much misused in India, and sometimes the level of the misuse of law reached to the highest level. Then the Supreme Courts and the High Court had to intervene into this matter. So similar things had happened in the Telangana, where there are many instances where the preventive detention has been misused, and there is a similar case related to the Justice Surya and Justice Dipankar Dutta, who had warned the Telangana state that do not misuse this law. So what had happened that this law has been used various times, and they had opined that we are moving towards the 𝐈𝐀𝐒 𝐏𝐫𝐞𝐥𝐢𝐬, but there are few police persons who are misusing this law and they are harming the liberty and dignity of a person. So in this way, this law is very much important, and so we are going to discuss in today's class. So this is the news we are going to discuss. So how much Telangana is misusing this law, we are going to discuss in this factor. So what is this preventive detention? So it is a detention measure in which that a person is detained without any trial, without any conviction of the court. So on what basis the person is detained? So on a basis of mere suspicion, the person is detained. So that's why this law has been highly criticized in the Indian law system. So this thing we are going to discuss, that why this law is misused, because their interpretation is very much different. The different courts have interpreted this law in a different manner, and also various state government has used this law in a various manner. So this is the reason that this law has been highly misused by various states and especially the Telangana. And why we are discussing this thing in the case of Telangana, because Telangana is going to see next month as its state election, and on many issues this issue is very important, because this issue is prominent because many people and innocent people are arrested because of this preventive detention. So that's why we are discussing this topic, and Supreme Court had also warned the state. So in this way, this topic has become very much relevant. So this is a brief about preventive detention, and various countries in war times and in the crisis time, they use this preventive detention. But in India, we have the constitutional backing for this preventive detention. So as you all know that part 3 of the Indian Constitution deals with the fundamental rights. And in part 3 we have this fundamental rights, who are the basic structure of the Indian Constitution. It means that they cannot be amended. But in Article 22 we have seen that there are few provisions which are related to the preventive detention. So in this way we have the constitutional backing for the preventive detention. So coming to this, that if we have the constitutional backing, then why this law has been misused? Because the interpretation of the law is very varied, and because of this interpretation this law has been highly misused. So coming to that, under what laws can the state order preventive detention? It means that under what kind of the laws they can use this kind of the preventive detention. So the first of all we will discuss in this thing in the central government case. So there are few cases, there are few laws which are related to the central government, such as National Security Act, the Conservation of Foreign Exchange, the Preventing of the Smuggling Act. So in these cases the central government can use this preventive detention. Coming to the state government, so there are 25 states who have this law, who have this kind of the law like preventive detention, including the Telangana also. And just like Telangana, prevention of dangerous activities of bootleggers. So because of this thing, this news has erupted and we are discussing this news. So Telangana is using in a very insignificant manner. That's why this topic is very much important. So moving to the next slide, that what are the powers of the state? So in which manner that law uses in the state? So what does that state authority gives permission to any district magistrate that you can detain a person, and they can also advise and give authority to any police person that you can detain a person. So this is the first step regarding this thing. And after this, that if the extension and retaining period exceeded more than 3 months, then they had to take approval from the advisory board. And who recruits this advisory board? So advisory board is constituted by the state government, and mostly it consists of the retired judges and the bureaucrats. So in this way we can say that this is totally a state system. And coming to the next process, that what next process we can have apart from the advisory board. So in front of the advisory board, any detainee has no right for the legal representation. They have right of the legal representation in front of the court, but in front of advisory board they generally don't have this legal representation kind of things. And if they are not happy with the decision of the advisory board, then they can challenge it to the high courts or the supreme courts. So this is the brief about that how state operates any preventive detention. So this is a brief about the preventive detention. So moving to the next slide. Next slide is about that how do court access the detention orders. So recently we have seen that Justice Surya and Justice Dipankar Dutta had to give review about this preventive detention. So there is a very narrow interpretation, and there is a very narrow space for this kind of thing. So in coming to the judicial review, where Supreme Court has full right that how they can review any law. So there is a very narrow judicial regarding this preventive detention. So because of this thing, this is highly misused. On the other hand, the interpretation also varied. Like Patna High Court had a different interpretation, but we have this apex court who had a different kind of interpretation, and they had said that by using this law, many fundamental rights, dignity and liberty of the person is harmed. So in this way, they have this interpretation that, we have this constitutional backing of the law, but this law should be used in a rarest of the rare case. It should not be used randomly, and it should not be applied to the innocent people. And here suspicion is not the mandatory fact that on the basis of mere suspicion you can arrest and you can detain a person. So this is the process of the court in which the court has accesses this preventive detention. So moving to the next slide. Next slide is related to the question. So with reference to preventive detention, consider the following statement. And your first statement is, it can be defined as the imprisonment of a person without a trial. And the second statement is, it is allegedly justified for non-punitive purposes. And here they are asking the correct statement. So you have to answer this in the comment section. Coming to the next slide, which is the mains question. So what is the mains question? Do you think that preventive detention laws are a perennial threat to the personal liberty of the citizens? Comment. So first of all, you have to give background about this preventive detention. Then you can give a intro, that part 3 of the Indian Constitution, and then Article 22. So these are the constitutional backing for the preventive detention. And so in this way you can give a brief intro about the preventive detention, then what it does. So it detain a person without any conviction of the court, without any trial, and on the basis of mere suspicion it detains a person. So you can give a brief intro like this, and then coming to that how it is a perennial threat to the personal liberty and the personal freedom. So coming to that, you can quote various cases, just like Merappan cases. So we have various cases which are related to this kind of the thing, and then you can quote the recent Supreme Court verdict and Supreme Court ruling on to this, that Supreme Court had warned the state that you should not misuse this thing. This thing should be used in the rarest of the rarest case. And why you should not use this thing? Because it harms the dignity and personal liberty of a person, and it infringes the fundamental rights of a person. So on the basis of all these things, you should not misuse this term. So coming to that, why this thing is written in the Indian Constitution. So in order to prevent law and order, and in order to prevent various crimes, this thing has been written in Indian Constitution. But this thing should be used in a very rare cases. It should not be used very randomly. So you have to write that what are the issues related to with this law. So the first issue is that here the background and the basis is very low. It means that on the basis of mere suspicion, one person is detained. And the second thing is that sometimes the detainment period exceeded because that person doesn't want bail, and this kind of things happened. There were so many political issues also related to it. So it is not just a legal affair, and it is not just related to the court affair. It is also political in nature. So it is very politically misused also. So in this way, for the enhancement of any bail period of a person, this thing has been misused variously. So in this way you can write your answer that it infringes the personal life and the personal liberty of the person, and it also affects the physical and mental health of the person, and it also affects the court proceeding, because it takes time for unusual things, for useless cases. The court has to devote their time because there are already pending cases which are running in the court. So these kind of the false cases should not be reported to the court. So in this way you can say, and that you can also tell and advise to the police that you have right to detain a person, but you should have a proper background, and you should give the ground that on which ground you are detaining a person. Also, it's not mandatory for a police and a district magistrate that you should tell the background and on which ground that person is detained, because sometimes they give this excuse that in order to prevent law and order, we are not telling that on which ground they had detained a person, but it should be mandatory that you have to tell the person that on which reasons and on which ground you are detained here. So in this way you can write your answer that the law is very good, but it should not be used randomly. So in this way you can conclude your answer. I hope you like this lecture. If you have any queries related to this lecture, kindly ask in the comment section. Thank you.